So are you going to take the cuffs off me, or are we going to backpedal that far, or no?
No, I'm not going to take the cuffs off you. You're detained?
No, I'm not.
Okay. I have a gentleman here. This gentleman.
Is this your son?
Don't go in my office.
Why is
That's not my son. So step back over here.
I'm sure it's not.
Okay. I got a gentleman here in the office who wants to record, and I've told him several times to get out of my building. He is claiming that he has the right to come in here and record at the police department.
That's sad that you do not know your own laws as a chief. You are... You're buddy. Excuse me. Don't stop touching me.
Gotcha.
Stop touching me right
now.
now.
Well, I'll undetain him and we'll go.
Oh, there we go. Oh, undetained. Dude, you better get people here, man. You better get people here.
Hey, you cannot curse in this building.
No, I can. I can say whatever the fuck I want to you. I can say whatever the fuck to you.
All right, I'm gonna detain him, Judge.
There we go.
And he's arrested.
30 times the charm.
All right, this is a building you cannot curse.
No, I can't.
It's disorderly conduct.
No.
Okay.
A few days following this incident, Chief was forced to resign.
Welcome back, everybody. As many of you guys know, I'm a law enforcement instructor and trainer. I train and instruct military and law enforcement all over the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, investigations, use of force, etc. This is a great video because it's a great video because here we have a police chief. We have a police chief that very royally messes this thing all up, violates the constitutional rights of this individual. And so this just goes to show that when it comes to training and when it comes to seniority, again, your seniority on the job does not have a direct correlation to how well you are at doing that job. And this video is evidently clear of that. And so there's a lot of things I want to dive into, I want to talk about, but let's talk about the first thing. The first thing we have is, does the chief of police even have the ability to detain and compel identification? Well, if we didn't know, we have a Supreme Court case precedence for that. As you guys know, this is one of my favorite Supreme Court case precedences. I think that this needs to be trained at every police academy because, believe it or not, this is not. I ask every single new law enforcement officer that I have come in contact with recently. It's something that I start to ask every single one of them. What case law did you guys go over at the academy? And they just give me this deer in the headlight looks like, what does case law even mean? And I'm not saying that to be disrespectful to the police academy apparatuses. I just know it's not something that's taught. I think this should be taught at every middle school, every high school. I think this should be taught everywhere. I think this is by and large foundational to policing, and I think that it's reasonable that everybody know it. And the fact that we have police chiefs that don't know it, that are actively operating, right? So we have police chiefs in the United States of America, in this great country, that are operating, that have no idea, have zero idea when they are allowed to stop and detain somebody. They have no idea. Don't understand the court law case precedences, and this is somebody that is the highest law enforcement officer of that jurisdiction. And so it blows my mind. It really does. It's very sad and it's unfortunate, the fact that he has to call a judge only for a judge to say, yeah, you better take those handcuffs off and better undetain him. So let's look at it. Brown v. Texas, 1979. Again, the Supreme Court has affirmed that law enforcement needs reasonable articulable suspicion of a crime in order to detain and compel someone to identify themselves. Again, Brown v. Texas, 1979. So obviously in this case, we can see that there was no reasonable articulable suspicion of a crime, at least not one that the police chief could articulate or establish. And so there you have it. That's going to be one huge issue there. The next thing that I want to really harp on and talk about is, let's talk about this profanity, cursing, right? Because as many of you guys know, many of you guys are aware of the Supreme Court case precedences on this. But what you may not be so aware of is that a lot of states, and I can't speak for South Carolina, I believe that's where this was taken from. This is where this video is from, this jurisdiction. But it doesn't matter because we have Supreme Court case precedent. So let me show you here in Oklahoma, where I hold a police certification. Let me show you some of the laws that we have on the books. You may not believe it. Don't believe your lying eyes. Look it up for yourself. So the first one that we're going to talk about is, we're going to talk about Oklahoma statute. So it's going to be 21905. 21905. You can see it up here on your screen. Every person guilty of profane swearing is punishable by a fine of $1 for each offense. Again, this is codified in our statutes. right? The last revision in 2023. So this is codified in Oklahoma statute. Again, don't take my word for it. 29-905. Every person guilty of profane swearing is punishable by a fine of $1 for each offense. So there's one. Let's look at another one. Let's look at Oklahoma statute 21-906. Obscene language, a misdemeanor when, if any person shall utter or speak an obscene language or word in any public place, comma, or in the presence of females, or in the presence of children under 10 years of age, shall be liable for a fine of no more than $100 or imprisonment of no more than 30 days. So you can easily see how a police chief who knows that this statute exists would be like, oh, you just cursed in public? Oh, there's a child there? There's a woman there? We're going to put handcuffs and we're going to take you away. Now, as ridiculous as that may sound to us, again, this is in statute. Again, this comes straight from Oklahoma statute. This exists in statute. And as you can see, the last update and revision, 2023. It's there. Again, don't believe your lying eyes. It's there. Now, do I think that's still reasonable for somebody to arrest somebody for that? Absolutely not. But then again, I'm the one that teaches constitutional law. I'm the one that actually studies this stuff every single day. I'm actually somebody that cares about constitutional rights. But you can see that this police chief, and again, I don't know who he is. I don't know as a person, but I have no problem calling a spade a spade. This arrest for cursing is one of the most ridiculous things that I've seen in a while, especially from a police chief. And again, I don't know this guy. If you know this guy, good on you. It doesn't change my opinion of that arrest. Okay. It's grossly negligent. That's just what it is. But again, there are state statutes where it says this, right? So you'd be surprised how many cops in Oklahoma actually know this statute exists. I've known of cops that have bragged about arresting people under the statute. So they exist. These people absolutely exist in real life. Again, I think the Supreme Court case precedent speaks for itself, but cops in these jurisdictions know that this is a part of criminal code. Call it what it is. I'm not here to tell you my opinions on it. I'm just here to tell you the reality of the situation we find ourselves in. Again, my personal opinion, if I can give it, I think it's ridiculous, is completely not applicable because we have Supreme Court case precedent. Supreme Court case precedents, law of the land, right? That's really the only thing that really matters when we are talking about these premises, right? Really the only thing that matters. So let's talk about the flag burning case law. Again, Texas v. Johnson, 1989. Texas v. Johnson, 1989. It's here on your screen. The Supreme Court has held that flag burning constitutes symbolic freedom of speech as protected by the First Amendment. It also affirms, right, the Supreme Court further held that freedom of speech protects actions that society may find very offensive. Okay? But society's outrage alone is not justification for the suppression of free speech. Again, says it right there. Plain and simple, brass tacks. Right there. Now let's look at another Supreme Court case precedence. This is a good one. Cohen v. California, 1971. The Supreme Court held states must have a better reason than concern for general disturbing of the peace when they ban displaying an explicitive in a public space. So in this one, you had I think it was, and I quote, "fuck the draft." T-shirt. Somebody had that on a T-shirt, and that person got arrested. I imagine his name was Cohen, based upon the case law precedents we see here. But Supreme Court says that can't be cursing in public can't be enough for disturbing of the peace. It has to be more than just that. And so here again, another example: him cursing at the police officer. It's completely irrelevant that it's in public. The fact that he used profanity in public is held and protected by the Supreme Court, and you've seen the two case laws in front of you. So what potential repercussions? Well, obviously we saw that this police chief resigned or was asked to resign. He is no longer a police chief of that organization, at least. But again, let's look at what some of the courts decide. Let's look at this one real quick. and you've probably heard me talk about it. Ikebusi versus Bolter, 1999. In this one, Sergeant Bolter, he lost his qualified immunity. The First Circuit held that a reasonable officer would not find that the peaceful activities of a journalist recording in public was enough to be considered engaging in disorderly conduct or disturbing public assembly. So in this case, Sergeant Bolter arrested a journalist because he was filming commissioners. Again, this sergeant lost qualified immunity. Again, the court said that that was not a reasonable thing to do. Let's look at another one. Kenneth Kennedy versus City of Villa Hills. And this one is in Kentucky. We see that the Sixth Circuit ruled that Officer Joseph Shoesman was arrested a man for disorderly conduct after he called the officer, and I quote, a son of a bitch and fat slob. This officer, Officer Joseph Shoesman, was not entitled to qualified immunity from a federal civil rights claim. The arrestee, Kenneth Kennedy, voiced may not have been heard loud enough or unreasonable enough, right? That they basically said that he was exercising his First Amendment rights. Again, Kenneth Kennedy versus City of the Villa Hills. So, yes, officers can definitely lose their qualified immunity for this. This is something that you can absolutely lose your qualified immunity for. Now, with this case in particular, I will put it on your screen here. Medalgia, whatever his name is, versus Middleton, as you can see here, he put in a civil action lawsuit here. If you actually go look at that civil lawsuit, it's been dropped without prejudice. So this individual that was arrested, his civil lawsuit has been rejected by the federal court. But the reason why, if you look at it, you actually take the time to read through it, the reason why it was rejected is because apparently he did not answer things in a timely manner. Basically, the courts basically said that he was not communicating or cooperating with the process, and so that ultimately the civil rights lawsuit was dropped in federal court. And again, it just goes to show you this, and the reason why I bring this up is because, again, transparency matters, the truth matters, but realize that, you know, if you do feel like law enforcement has violated your rights and you are going to go forth, there is a process, you know, and that process can be timely, it can be resource intensive. And so if you decide that you're going to go after a law enforcement officer, a city, what have you, and you're going to go through the process, the adjudication process, you know, you have to go through the process. And in this case, again, we saw that it was ultimately dropped. And when you look at the reasonings outlined in the civil suit, it's because, you know, untimely timelines were not kept by the person trying to get redress of grievances. Communication lines were not there, and he failed to provide evidence and documents as necessary. So just know that that's probably one of the reasons why we do see that there aren't more of these cases out there. There's a bunch of them, but there is a process, and if you're unwilling to go through the process, don't expect there to always be those remedies that you are expecting. And again, not my opinion on the matter. This is just the truth, right? So I'm here to give you the factual truth. I have listed everything here for you to look up on your own. Do your own research on this, because again, my job is to provide you the reality. And that's the purpose of this channel. So again, there's a lot here. Hopefully you guys have learned a little more than you did before. If you guys like this content, please like, share, subscribe. Question to you guys out there. What do you think should happen in this case? What do you think things can happen to change? What kind of training do you think that law enforcement should be conducting? And what do you think about the fact that this was dropped because the individual in this lawsuit decided not to go through the whole process? What are your guys' thoughts and opinions on that? I would love to hear them in the comment section below. And as always, guys, long live the Republic.